Mayor hides the crime rate. Councilwoman hesitates. Public gets irate, but forgets to vote dates. Weatherman complaining. Predicted sun, it's raining. Everyone's protesting. Boyfriend keeps suggesting you're not like all of the rest.
Okay, Mike Nichols is back by popular demand. Second episode or part 2.
You know, I'm sorry I'm a few minutes late, but I wanted to get the right amount of blue. I didn't want to outdo the blue guy, but I see that you opted for the pink tie today.
Well, you only got so many when you're single. You're lucky to get anything.
Yeah, that's my only witticism. I tried to think of some witticisms for today's taping, but that's all I got. So I'm going to rely heavily on you, like I often do.
Thanks for coming. I guess we should say that Mike got a gift card to Sidebar and a gift card to Showroom Shine, so he's kind of like a paid guest now.
I'm excited about the Showroom Shine, almost more so than, I mean, it goes without saying I'm excited about Sidebar, but my car is really a mess.
Well, the last hour went by so quick, I was surprised when I got the 50-minute sign, and we really didn't talk about any of your major cases. And I know I didn't run these questions by, but why don't you tell me about some of your bigger cases?
Well, we talked about the Holland case.
Right.
And I'm not even sure we gave that justice, but that was a big case. And we've had some other big cases. One of my favorites was one that we did, and I don't know if I'm allowed to say this, but, you know, we basically did it pro bono. Maybe some people don't know what that means, but it means we gave our services. Right. And it's because I think the motivation was the county prosecutor was so overzealous in not just the way they charged it, but they went public with it, right? Like, you know, we're going to make an example out of this young man and his suffering, because he really, you know, he had some problems.
Right. And you're talking about the case where there were two motor vehicle. One was a motorcycle. The next one was a van in which two people died. He
had the horrible, awful, granted, you make some choices to put yourself in that position, but his luck was so bad. He had a motorcycle incident where his friend died, a really good friend of his, and then within a fairly short period of time, he was driving a work van at about, 5:30 in the morning or something?
Something early.
And smashed it into a tree, and another friend died.
Right. And just so the listeners know, because a lot of lawyers say you probably can't talk about this case or that case, and the law doesn't prohibit us, nor does the privilege prohibit us from talking about cases publicly. Almost all of what we would talk about here would be part of a public record, and certainly that wouldn't be privileged. What's privileged is what your client tells you or what you tell your client. And so we're not talking out of school, but obviously there is a lot of public interest in cases that we handle, partly because we do criminal defense and people have sort of a listening ear for those kind of cases. And they often ask that question, you know, what would you do, or would you be compromised if you knew your client was guilty? I mean, we get that all the time, and I'm especially troubled.
How do you sleep at night is the one
Right. I'm especially troubled by people who ask that question, who I consider to be highly intelligent.
Right, and they struggle with, you know, a lot of basic civics. Like the last thing that any of us would want to be without if we're up against our government accused of something, whether we did it or not, is good, aggressive, zealous legal representation.
Right, exactly. And, you know, I've never had a client who was quote unquote, let's just say he did it, because you're not guilty until a jury says you're guilty. But I've never had a client say, you know, I don't want to tell you that I did it because I want you to sleep at night. You know, they want you to represent them, and they want that comfort that you're going to work hard to either get a best possible plea. In that particular case, as tragic as it was, resulted in a plea. But
it did.
There was some great lawyering on your part, especially at the preliminary exam.
Oh, we had so much fun.
And it was a
had so
tough
much
case.
fun.
It was
Yes.
the premise of it was, an auto accident isn't necessarily a crime, but can arise to a crime depending on who was injured and who's at fault, right?
Yeah, and a lot of what was so fun about the case is the government brought in this scientist, I'm just going to say her name, Michelle Glynn, PhD, who is really...
In philosophy.
Yes, or as some say, piled higher and deeper. But she's really more of an advocate. I'm just going to be blunt. She's really more of an advocate than a consultant / expert witness.
And you've had her on a number of cases.
Oh, yeah. I have tried to make it, sort of a side mission to really make her life difficult and when it comes to testifying, not in general.
Right,
but
right.
Because I just find that she is almost every time she's on the witness stand, she's trying to get a conviction. And it shouldn't be about trying to get a conviction. It should be about explaining to either a jury or a judge, this is the science. This is how THC works in the human body. And this is they call it psychomotor effect, but basically what it does to you. It makes you silly. It makes you drowsy.
There's a difference between educating and advocating. And
Yes.
There's a fine line sometimes, and sometimes for a lot of people, there isn't a fine line. They're way over the line.
And if you're a young lawyer or not so young lawyer or a law student, when I use an expert witness, I don't want that expert witness to testify if they're going to try to win the case for me. I want that expert witness. I'm not going to put them on the stand, first of all, if they don't have an opinion that's going to help our theory of the case. But I want them to recognize that every opinion, an expert gives an opinion, right? That's why they're there. Every expert opinion has limitations. It's not going to be perfect. It's not going to, it's not like My Cousin Vinny, where Marissa Tomei testifies and the prosecutor says, state dismisses all charges. It just doesn't work that way. And it's all part of the story, all of the pieces of the theory of the case.
And just so maybe we give a little background, because I often say that a drunk driving case is as complicated as any case you'll ever have.
Absolutely.
And part of the reason why that is the science of a vehicle.
Right.
The moving vehicle, right?
The physics.
And when there's an accident, you have the black box, right?
Yes.
And when there's a death, you have, the accident reconstruction experts come out and they measure everything, right?
They should, at least they're supposed to. They did not do that in the case that we've been discussing.
Right. But so you get the black box, you get the measurements, the physics, so to speak, and then you also have the science of the body and how it processes, whether it's alcohol or drugs and how that affects the body. Right?
And these days, the big one is THC, because of the fact that THC is now legalized for recreational use in Michigan and about 24 other states.
Right. So, all of that and determining, and in particular, although it's, with alcohol, we have this bright line, 0.08. If you're above it, you're under the influence. With drugs like THC or meth or name the drug, there is no bright line like that.
Right. It's simply not the same. And, somebody who uses marijuana every day is going to really have a much different, they call it dose response, right? It's not going to make you high the first, 10 minutes that you take 3 puffs off a pre-roll or take a gummy. your body's going to respond to it differently if you're used to it or accustomed to it.
And not only marijuana, but there's a number of prescribed drugs that would affect you the same way if you're taking it on a regular basis.
That's right.
Correct?
I mean, grandma is going to maybe use an anti-pain, maybe a Z drug or maybe some other kind of medication to help her cope with arthritis. Does that mean grandma should never drive again, even though she takes it daily? Well, no. It's, grandma will develop a tolerance. I shouldn't pick on grandmas, but she'll develop a tolerance over time. And if there's an accident, I've seen, police officers who just jumped all over that. Are you taking any medication today, ma'am? Well, yes, I take my daily dose of X, Y, and Z. Oh, it must be because you were impaired by your medication that this accident happened. That's horrible. And you're going to, it's like you're casting a net to catch tuna and you catch a dolphin almost every day. And we don't want that. I mean, we're not saying drunk driving or drugged driving is okay. Just throw the dolphin back. You don't have to stop tuna fishing with nets. Just throw the dolphin back.
Right. And so, that process is sort of the expertise in that area is toxicology, right?
Correct.
And
pharmacology, toxicology.
And you've become what I'll call a expert by experience.
Well, I've also spent tens of thousands. Wendy would probably have the exact number for you, but hundreds of hours and many, many dollars going to conferences to learn and educate myself on the various issues.
And so, interesting thing, let's bring it back to that case when the mother first came to hire me. She her son was in jail facing two separate independent charges, each for of driving a vehicle causing death, both under the influence.
Yeah,
which are 15 years.
Yeah,
yes.
We had to litigate two death cases, man,
on separate occasions.
Right.
And the minute I heard about the situation, I was interested by its uniqueness, but I instantly thought, I don't want to get in this case without Mike Nichols. And I don't want to do the heavy lift to try and convince him. And this is a little secret of mine that I'll let you in on. Whenever I realize it's going to be pro bono, I want to share the risk.
Right, 100%.
And
absolutely.
Come on, Mike, you want to do this case with me? But I didn't want to convince him to do it. So I said, look it, and this isn't privilege because it wasn't the client, but I said to the mother, I said, if you can go convince Mike Nichols to get in the case, I'll do the case. And I called you up and I said, if she's coming over, let me know. And somehow she convinced you to do the case.
No, I wanted another adventure. I mean, going back to that case in 2005, I don't think we ever decided what year it started, but 2005, the Holland case, that was a great adventure. That was a great ride. It didn't turn out the way we wanted it to turn out, but we had a lot of fun. We learned a lot, and we did what lawyers do. You go into court, you sweat, the pit stains, under your arms, and you work hard and you think and you try to be at your best every single day. And on Wednesday, you try to be a little bit better than you were on Tuesday, and you go in and try to win.
Right, and anytime the outcome is uncertain, there's always a possibility that it's going to go against you.
Yeah.
If it was easy.
That causes anxiety, for sure.
If it was easy, anybody could do it, right?
If it was easy, yeah. If it was easy, anybody could do it.
And so, that case was complicated, and we had to run two separate preliminary exams. And I don't know if you remember this, but I remember when you were cross-examining Michelle Glenn, and he happened to have THC.
Right.
And I think he had meth in his blood. He had some other.
There was a third substance in his blood. I don't remember what exactly it was, but we had a very low level of alcohol. We had a pretty low level of marijuana, and then the third thing, but I don't remember what it was.
Right.
I think it was an amphetamine, though.
It was an amphetamine, and in your cross-examination, you pointed out that that amphetamine would actually help because it would keep you awake and keep you alert, or it would be a contra to the alcohol and the THC. And I think Dr. Glenn had to agree with that.
That's right. That's right. It doesn't have necessarily what they call a symbiotic effect. It makes you drunker or higher or whatever. I'm trying not to talk like a lawyer. Increases that effect on your body and your brain. It will counteract. The two will counteract one another.
And ultimately, we ran the preliminary exams. He was bound over to circuit court, and we resolved the case
in a very favorable way. I think he's out of prison now.
Yeah. So it wasn't that we went to trial and he was found not guilty, but they originally wanted something north of, I think, 18 years, and he got, I think, 6 or 7 years.
Yeah. My memory too was Dr. Fran Gengo, Gengo from Buffalo, New York. We hired to consult with us on the case. I don't think we ever called him to testify, and sometimes that's a really great weapon to have. You have someone who's listening to you cross-examine the expert, who helps you understand some of the things that you may not as they're coming out of that expert's mouth. Sends you notes. It helps just make you a little more effective advocate, because when you cross an expert, you got to be an expert too. In fact, you've got to be a better expert and a more confident expert than they are.
Right, because you've lived the case.
Right.
And that expert is being retained, but you still have to know as much as they do, if not more.
Yeah. And the funnest moment of the entire case was at the preliminary exam in front of Judge Allen in that old courtroom, really dark. And I'm doing my cross-examination of somebody. It might have been Dr. Glenn. I don't know. But you go sit in the jury room, the jury box on the other side of the courtroom, the other side of the well from Judge Allen's bench, and you got up and you moved, and the prosecutor objected and said, "Mr. Abood's moving." And your response was classic. I think you said that's not anywhere in the rules of evidence that I'm aware, Your Honor.
It was a stressful moment for him, but
yeah.
Which you can do that sometimes to people.
Yeah.
Because you
got a specialty in that.
You were in control of the situation, and you probably had their expert on the ropes, and everything sort of bothers you when you feel like the other lawyer's scoring points.
Right. The stress is just building up, and you're trying hard not to let it get to you in a manifest way where you're going to stand up and object or yell or do whatever.
I think that's a case where you can look back and say, justice was served.
Right.
Yeah.
And let's make sure it's clear to everybody, we did what we do with a lot of these clients, and that is not just busted our butt to get him the result in court, but we also busted our butt to counsel him on not putting himself in that position again and getting on top of his life and his relationship with controlled substances.
And I think that, if I remember right, that was a case where we brought in Andreas regarding
Dr. Stoltz?
Yes, regarding the motorcycle accident, the first case.
Yeah, that's right.
We went to the where the motorcycle was being stored, I think, and we took pictures of that motorcycle and the damage. Just trying to, understand completely what value do you see in going to the scene or going to inspect the evidence.
Well, it helps you visualize what happened. And when you're asking witnesses questions in the courtroom, it didn't take me long to realize I can't picture what they're talking about. And maybe that's just part of how I learn. I learn visually. Maybe it's because I'm a TV kid. I don't know. But you got to be able just to see it, to understand, okay, this road goes this way, and it does we had a really strange bend in the road, and we had another intersection, and we just had to go see it.
A hill, and yeah. Yeah, no, I always think that when you read the police report, you get a picture in your mind, right?
Right.
And, that picture may have absolutely nothing to do with the real scene, and it may be very similar, whether it's a a homicide in a house or a stop or, a road or a parking lot. They maybe, you can imagine a parking lot, you can imagine it being dark, but till you actually go, and see the actual events,
At least half the time, I'm wrong when I read a police report and I visualize what something looked like.
Right.
I mean, I did a murder case that happened on 4/20/2020, and it was the felony murder. They went to commit a robbery. They were robbing a guy with marijuana, of his marijuana. So just a straight-up homicide, not a drunk driving or anything. And I'm reading, a huge police report, hundreds of pages, and I'm trying to picture what this guy's apartment looked like where it happened. And I just said to myself, I got to drive up to Mount Pleasant. I just got to go look at it. I got to go see if they'll let me in the apartment complex. And I'm just going to tell them, I'm a defense attorney. I need to look inside one of your apartments, preferably the one where this happened. And they let me in, and I was wrong. The way I envisioned the whole setup and trying to hear my client explain what happened, I had to just see it because my mental perception was completely inaccurate.
Right. And, that happens time and time again.
Right.
Right. It's not just a unique thing. I think in the Ricky Holland case that we talked about the last time, the initial allegation by Tim Holland was that Ricky was dragged out to the hallway, hit over the head with a hammer, and bled to death. And, that kind of scene would leave blood all over the place. And then when we went to the scene and they ripped up the carpet, there was no blood anywhere. And they had to change their theory.
Right. And I'm kicking myself. I still do ever since, the verdict and the sentencing. Remember, I demanded I get a chance to interview the MSP lab forensic scientist. She did a whole bunch of different things, and I went into the prosecutor's conference room, and I think Mike Ferenczi sat in on the interview, and I think one of the investigators, Roy Holliday maybe, I don't remember, sat in on the interview, and I should have said, I want to talk to her alone because I wanted to just say, what do you think happened? And I was afraid to do it in front of those guys for some reason. And it wasn't until...
It was Ann Gordon. Ann Gordon.
It wasn't until after I saw Ann at a holiday party and we had a chat, and it was, way too late. And she said, no, yeah, what Tim said is just not, there's no way it happened that way.
Right.
Because of what you just described.
Right. I mean, and that's unfortunately, that's something that can only come from experience.
Right.
And, I remember those days. But one of the things that is interesting that I want to talk to you about is maybe the lost art of chamber practice.
You mean chambers of the back bar at sidebar?
Well, yeah, no, not quite that. But it used to be, and it's less and less anymore, but you could request a chambers discussion with the judge. And, there's some judges that still do it. And there's an art to that. And I'd like to know, do you have any particular strategy when you go in, when you request a chambers practice? Is it something you still try and do? And what are you looking to achieve?
I've just never been a big fan of off-the-record discussions with the judge, either in the judge's office. Obviously, you've got the other lawyers. The other side is there, too, because if you go in by yourself, that's ex parte, meaning...
Right.
And that's a no-no. But the reason why I don't really care for it is, you're asking the judge to take a position that the judge may not ultimately take, like maybe it's on a sentencing, and you say things that you would not say on the record about your client or about your case, and it's not, the judge is being asked to be bound by the representations of the lawyers that aren't really supported by the evidence. The prosecutor might start talking about, well, the police report says this, and you're not going to believe this guy did that. And, okay, prove it. And I find myself not really losing my temper, but just getting annoyed with representations by the prosecutor that I think, you're not going to prove that. I'm going to cross-examine the bejesus out of that witness on that.
Right.
So it's really kind of faded a lot, I think, with the newer judges. Have you noticed that?
Yeah, for certain. And not only the newer judges, but the chambers themselves don't always, in Ingham County, to get back into chambers, it's, you got to know several passwords and get by 3, people or 2 people before you can even get into chambers. But I know that in the Holland case, we did a lot of chambers discussions.
We did, with both Judge Aquilina at district court, because she was a district court judge back then, and then Judge Manderfield, who was, and I thought Judge Paula Manderfield was fantastic on that case. She did a really good job.
Right, tough case.
Tough
Very
case.
tough case. And, even at the time, Mike Ferenczi was like a heavyweight. And, a lot of things that she deferred to him on, we were just sort of, I don't want to say second fiddle, but he really, pushed us around until we got very close to trial, and then we started to assert ourselves.
Yeah, you really were awesome. I'll never forget you and Mike about a half inch away from each other, nose to nose, and there was some discovery violation that, we thought I'm pretty sure we caught them in, and you really let him have it. That was great. I was like, you go, Andrew.
Mike was a good guy, and he was a great lawyer, but in particular, in the chambers thing, what I regret the most, a couple of things I regret about that case, but we did a pretrial jury questionnaire.
Right.
And I think we allowed Mike to do the first draft. And it had like 6 questions on it.
Yeah, and they were just pathetic.
Yeah.
They elicited nothing.
And
what's your favorite color?
And I remember we went through those questionnaires. There was, 300 or 400. And we did that in chambers. And it was you and I and Mike Ferenczi and Roy Halladay and the judge and maybe one other person. And I remember
Sarah Belzer, the judge's law clerk.
Oh, right. And I remember we went through it and we decided that if there were only 2 guilties, that was like, that they had passed the screening, that they could be a fair juror even before they had heard any evidence. And I think back about it now thinking, how did we not have 300 questions about, what they had read and when they had read it and how many articles they had read? And
it took forever, and it should have taken probably longer.
We should have, I should have done better. And then, of course, I've told you this before, but we should have found all the experts that we could have,
right,
as far as a forensic pathologist.
Right. Yeah, we so many holes in that case, and we can't undo it now, which is, of course, very regrettable. And you just got to find a way to forgive yourself and move on. And the only way you can really move on is just do better the next time and not make the same mistake. And sometimes it's an act of omission. I should have done this. I should have said that. I should have prepared this way. And, I've just learned if a case is worth trying, it's worth treating it like it's going to be your last trial ever.
Right.
But before we leave the chambers discussion, the case that we did together where we represented the judge and we had the visiting judge in Battle Creek,
right,
we would go into chambers and talk a lot, and because he was an advocate for that. He liked to get to see how everybody was doing, make sure everybody's mood is decent, and they're going to go into the courtroom not angry about something or mad at each other. And so he would bring the township attorney and you and I into chambers, and you two would go at it because he was a Michigan guy and you were a Michigan State guy.
He had all his Michigan Michigan
He had a
stuff.
shrine. It was a shrine to Bo Schembechler and Lloyd Carr, and you would just rip them to shreds. And I think he really enjoyed the banter, but you get some of your one-liners were great.
I never refused a Chambers meeting because I think there's a comfort level that the judge, it's almost like an introduction, but it's often an opportunity for you to, like, especially when you're a defense lawyer, because often you're going up against a prosecutor who's in front of that judge day in and day out. And when it's one thing if you're in Ingham County, but if you're, out of county, right?
In a place where you don't really practice very much.
Right. Or not, obviously not as much. Even the interaction between the prosecutor and the judge is helpful to see, how comfortable are they? Are they, going to just side with the other side, or can you make headway, And I often think, if you can get some kind of bond, especially if somebody's going to put all their Michigan stuff up. Or,
They're asking for it.
Right.
Yeah. That judge was great.
That was one we won.
Yeah,
that was one we won.
Yeah.
That was one we won. So in addition to that case, tell me the Holland case, and you talk about lessons learned. How have you used those lessons in other cases?
The biggest takeaway is, we talked about that cross-examination I did of the forensic anthropologist, and that gave me a level of confidence. And you've just got to know that when you're cross-examining somebody and they're an expert, you have got to be confident. Even if you don't feel confident, you got to find it somewhere. And because when the witness is on the stand, you've just got to have that look in your eye, right? I don't want to glorify F. Lee Bailey with all of his shortcomings, but he was a great trial lawyer and a great speaker.
For sure.
And one of the many conferences that I've done in my career, I went to Harvard for the National College for DUI Defense summer session. And it's when I was going every year. And F. Lee spoke, and he talked about the power of the glimmering eye. And in the OJ trial, even if he didn't do the best cross, in fact, he said, I don't think my crosses were all that good, but I had that look. I had that glimmering eye, and that witness knew that I was in charge. So I think that's a big takeaway.
One of the things you did with Todd Fenton, though, is you were prepared.
Yeah, I mean...
You were prepared. And to me, great cross is you ask the question, you get an answer you didn't want. You knew they were going to fight you. You ask the important question, the witness fights you, and you're ready for it.
Right.
You're ready for that turn, that whatever they were going to say, you knew they were going to go there. And you've got 5 questions that are going to get them back in line, right?
Yeah. You've got you got to use your ears, you got to listen, and you got to follow up where necessary. Or maybe you don't. Maybe the witness fights you and they say something completely stupid. And the jury knows it, and you just maybe walk over toward the jury box and say, okay, that's your testimony for this jury? Enough said. Right. And you just leave the rest of whatever you were going to ask about that topic. Leave it. It goes on the cutting room floor because that witness just buried themselves. You don't need to do any more cross.
Right. And that's always critical because in many cases in a criminal defense case, almost all the work often is cross-examination.
Right. When you're a criminal defense attorney. Yeah.
lifts.
You're usually telling your client's story through the cross-examination that you do.
Right. And you particularly sort of have manifested yourself in the expert realm, as far as being able to cross-examine experts. And tell me, give me some of your tidbits about how you, besides being confident, and besides talking to your expert, how do you get to where you can be ready to cross-examine say an accident reconstructionist or a toxicologist or somebody like that?
Number one, you just have to know that there's no quit. You know, you might get some superficial response from the expert, and they want you to just go away. Here's, you know, and especially, I'm not being critical, it's just what they do, but the Michigan State Police, their playbook is they send their experts to a school, to a class, they come up with buzz lines, catchphrases for you know, this discipline or that, and I was kind of ready for it when a guy named Felix Adatsi, he used to run the Michigan State Police toxicology lab up in Ludington, in a case that it's very public, so I'll just say the name. It was People versus Jabraki. And
famous case, really.
Yeah.
I mean, changed the whole policies at the state police, correct?
Changed the way they did testing. And I knew he was going to come up and say, we test it twice and we only report the lower of the two numbers because that's a benefit to the accused. And, you know, that's such a crock. And they would just give you one number. In this case, the number was 0.29. And I think, again, this was through the NCDD and a guy named Ted Vosk, who's from Michigan, who I think practices in Washington State, you know, was teaching that when you do good science, when you do a measurement of anything, you've got to recognize the principle of uncertainty. There's no true one single number. And I knew I was going to get all the you know, the buzz phrases from Dr. Adatsi. And I remember, you know, just waiting for him to spit it out. And it was dark. It was, I think, probably February in Judge Pete Wadel's courtroom in Ludington. Old school courthouse, man. I mean, it was like you could have been in a one-room schoolhouse from the 1920s. And we're all sitting there, and Judge Wadel's in his robe, and he's like, we're not going anywhere. I want to hear this. We're going to finish this. Judge Wadel was a lawyer in Lansing for a long time, and his practice area educated him on statistics and some science issues. And so he was right there with me on the issue of uncertainty. And I just knew it was coming, and when it came, I jumped on it, and we just went. There had just been another thing is you got to stay current, right? You got to try to stay current, whether it's politics or you know, government. There had just been a report from the National Academy of Sciences that criticized forensic science in the United States because so many people were getting convicted with
and forensic
bad science.
Let's be clear, is often run by the government.
Correct.
Like 80% of it, right? And so a criticism of forensic science is often criticizing the way the government convicts people.
Yeah, and it really was born out of the fact that people were going to death row on bad science. Just absolute junk, garbage science that, you know, somebody got a big ego and they were getting paid money to go propagate this theory. And, you know, I can think of one very tragic situation, which was an arson where some kids died. And I think his name was Cameron Willingham. He was executed. And after he died, the investigators went back and everybody agreed, okay, our theory that this was an arson was flawed.
Right.
And, you know, just following stuff like that is important because it helps you stay current and you know, and you've got weapons.
Trend. You can hit on a trend of people's feelings and emotions. And you were knocking at the door in an old school courtroom. And when you say old school courtroom, you're talking could be as many as 100 years old.
Right.
And you're doing state-of-the-art science, right?
The Mason County Courthouse. It's beautiful, and it's right there. You can, you know, look at Lake Michigan from the top floor. But I'll never forget that. It was dark, it was cold, and I was driving back at about 8 o'clock at night thinking, I think that judge is paying attention to this. Right. I think we're going to be okay.
In a place where you're not from.
Right.
Never don't practice in that courthouse. Never in front of that judge.
I never met Pete Wadel before that day.
Got to feel like everything is stacked up against you because the prosecutor probably just had to walk upstairs in front of the judge all the time. And, you know, this Mike Nichols from the big city of Lansing is just talking hogwash, right?
Crazy talk, yeah. I remember hiring as local counsel a guy named Gary Springstead, who's now got an office, a very big law practice in Grand Rapids. Springstead, Bardish, Borgula, and Lynch, I think, is their name. But he still keeps an office in Fremont, which is, within an hour of Ludington, and he went there a fair amount. And I just knew Gary because he was like the liaison for lawyers who did the overflow work for the Federal Defender's Office. You were basically doing court-appointed work.
Right.
And Gary was kind of the guy who rounded all of us up. So that's how I knew Gary. And I said, Gary, I need some help with a local attorney who knows Judge Wadel. And he gave me some confidence by saying, he'll pay attention. He's a pretty smart guy.
Right. Sometimes that's all you can ask for.
Right. And I probably called you on the ride home, and I said, you're not going to believe it, but this judge was actually paying attention.
Well, I think that's a case that you did almost all on your own, really. I mean, you were single-handedly, most people didn't know what you were talking about.
Well, I had a lot of support from not just my colleagues like you, but the National College for DUI Defense. There's something called a listserv where lawyers will post and answer each other's questions and talk about cases and trends. And, Ted Vosk was on those posts, and Don Ramsell, and all those guys who are there to, and women who are there to answer questions and to help you, just feel more confident when you go into court on something crazy like that.
And I don't think you could have a better foe than Felix Adazzi. I mean, not that he was your adversary, but he often has a tendency to be an advocate.
Right. Not. I would say not to the level of Dr. Glynn, but yeah, he would be there to help get a conviction. Which again, that's not science. Science has nothing to do with whether the box not guilty or guilty of count 1, 2, or 3.
I thought
which box is checked? It doesn't matter.
I thought he was the master of the overstatement.
Yeah, he used terms like gold standard.
Right.
And,
I think he compared the PBT or the breath test in a trial that I had to is it the nuclear clock?
Atomic clock.
Atomic clock.
Atomic clock.
He said it was as reliable as the atomic clock. And
that's what he would say about the data master.
Yeah, I said, "Are you out of your mind?"
Yeah, we had some fun times with the data master too. Yeah.
So one of the things that has made you, the state of the art on OWI is you wrote a book on it.
I wrote a book in 2009.
And, lawyers do a lot of writing, but we're not necessarily book writers.
Right.
So tell me how that came about.
Well, I think I've got the blessing of that was my first career was in journalism, and I like to write. And I knew that Michigan did not have a drunk driving practice manual that the main publisher, West Publishing, put out. Ickle did a book with several chapters that's very helpful. But I remember going again to, and I'm just going to say NCDD for National College for DUI Defense, but I went to an NCDD event in Las Vegas, and I met a guy named Aaron Michiu who worked for West. He had a booth, and I said, I'm from Michigan, and I'm a writer, and if you guys have interest, I'd like to propose a book. And it just went from there. It was just the one-off, he's there at the booth. I told Wendy, I'm going to stop by and talk to this guy real quick. And I just hit him up, and it went from there. And I spent the entire summer. Wendy was pregnant with Morgan. I just wrote and wrote and wrote I still had to practice and make money,
right?
But I would just write every chance I had. The whole weekend I was writing and researching and reading cases and, trying to map out what needs to go in the book and the flow. And that was a labor of love, brother, I'll tell you. Because I don't really make a ton of money on the royalties at all. It's not a deal where you're going to get rich from writing books.
No, but it's giving you what you may have not made in royalties. I'm hoping you've made it in, client confidence and something you can post on your website. And,
yeah, absolutely.
And the book is out and it's on in your office when the client walks in and, courts have it, maybe, and everybody has it, right? It's been a resource across the state.
Absolutely, and I've updated it now. This will be update number 15, I think, and that's on my list of things to do. There are a lot of Fourth Amendment cases that came out in Michigan, and I got to get those in the book.
And the Fourth Amendment is critical to DUI.
It is.
Right? Because part of the issue in the DUI case, why it's so complex, is how do they go from a civil infraction generally, which is the stop,
Traffic stop for headlights out,
to arresting somebody for a crime.
changing their life.
Right.
Yes, and it's our job to check. I mean, I've got a lot of friends who are cops. I've represented cops, but it's our job as lawyers to check them when they think they screw up. Maybe it's not intentional, maybe it is, but the bottom line is I got a client to defend. I got to try to get this person out of this. And if you violated the Fourth Amendment of the Constitution by engaging in unreasonable conduct and exercising your power, that's a lot of power to say, hey, stop or pull over. Red and blue flashes are on. You got to pull over. And if you don't, that's going to be another crime. That's going to be a charge for felonious fleeing and eluding. So that's our job. And the Fourth Amendment cases, I try to track really diligently. And that's another benefit from doing the book is it forces me. I mean, if I'm going to be the guy who wrote the book, I got to stay on top of that stuff.
You have to.
Yeah. And my clerks, like, Jackson over here, I make them read those cases. And I'm like, if I don't have time to read it, I need you to synopsize that for me so that I, speeds up my triages my workflow.
Yeah. So, the state of the art of being an expert in an area is not only knowing the facts, right?
Right.
Not only knowing the science, right?
But knowing the law.
Yeah. And then mending them all together. And even if you know all that, right, you can know all that, but you might not be a good advocate. You might not be able to be, persuasive in the courtroom. So on top of all that, you have to be able to somehow figure out how to win the case.
Right. Yeah, you gotta figure it out. And we just had a case in Gaylord, which was a death case, pure marijuana. The client was a medical marijuana patient, and a lawyer up there who's a friend of mine in Traverse City, Robert Wims. He said, "Look, man, she hired me, but I need help." We had a controversy at that time about how the lab was analyzing THC. They were literally analyzing the non-psychoactive CBD as THC. They were literally converting it with their methodology. And as it turns out, it had nothing to do with this case. To me, she had a very low level. It was 7 nanograms. And are we out of time already?
No, we're good.
Okay. She had 7 nanograms, and as a medical marijuana patient, she's going to wake up with that, right? She's going to wake up with that in her bloodstream. And Rob wanted help on we call it a Daubert hearing.
Right.
You're filing a motion to say the scientific evidence is not reliable. Judge, keep it out of the trial. And that's where I first met, well, not the first time I met Judge Hunter, but the first involvement I had in the case was fall of 2023, just sitting with Rob at the evidentiary hearing and kind of giving him feedback, helping him prepare. He ran the show, did a fantastic job. He was very well prepared. He retained Dr. Stoltz to help analyze the data. And the judge said, look, man, I disagreed with Judge Hunter at that time, but he said, look, I think this is reliable. Jeff French came up here from the lab, and he says it's reliable. They had analyzed it a second time because they had to change the method. It was so screwed up, they had to change the method. So they analyzed it again with the new method. And I just remember thinking to myself, Rob can win this case. But he won't mind me saying this. He was so focused and so worried about keeping the 7 nanograms out of evidence in front of the jury. I said, Rob, people will get it. Let me just help you with this case, okay?
And that's a great point. Because some of my best cases are the ones where my clients have taken the stand and confessed.
Right.
And they actually admit to doing exactly what they were charged with. But the jury hears it all and it makes sense. And if you have a good client who can take the stand, and it really takes a master to be able to see, hey, this is still a winnable case. I know in law school you're lining up all the elements and looking at all the evidence they have, but this isn't a law school exam.
Sometimes a person just needs to take advantage of that small probability that they're going to be found not guilty by going to trial, right? I mean, there's a 100% chance you're going to get convicted if you plead guilty.
Right.
And that was...
But it's hard to do. It's really hard to do. I mean, but you did it in that case.
I remember that week, and she gave me permission to talk about it because, we did it pro bono. Carolyn Riggs, a Marine Corps veteran who got hurt when a bomb fell on her. They were loading it onto a plane. And so that pain she learned to manage with medical marijuana. That was the best method for her, better than, Z drugs and everything, all the synthetic stuff. And she killed her husband on the way to work on a late March day in Michigan.
Well, her husband died.
Her husband died. I shouldn't say she killed her husband, but her husband died.
And that's a fact that probably weighs into her favor. That it wasn't a third party. That it wasn't another driver or a pedestrian. It was somebody she loved.
And she was frantic not frantic, but clearly affected at the scene and then at the hospital. And to me, this was where I read the police report, and I wasn't quite totally accurate about the picture that it painted, but I could kind of see in my head, this cop goes to talk to her an hour or so after this crash, and he doesn't write anything in his report about, red glassy eyes, the odor of marijuana, none of the visual cues that an officer might put in a report.
But never thinks she's high or under the influence. It's only from the blood, is what you're saying.
And I told Rob, I said, let me cross this cop, because this cross is about what's not in the report. And then I had one of, I think it was either Will Boatman or Julian Moses, one of the two clerks who were working with me that summer. Maybe Sam Edwards might have been, but they went to FedEx Kinko's, and I had them blow up the 10 National Highway Traffic Safety Administration cues of an impaired driver. And, I didn't put the board in front of the cop during the cross, and he was honest. He was forthright about everything. Right. I just said, you didn't see this, you didn't see that, didn't smell this, didn't say that. Literally took the language used in their training manual right out. And then I blew it up on this, and I showed the jury. I said, this is the lack of evidence, because reasonable doubt, the instruction in our system, I don't love it, but it's reasonable doubt is based on the evidence or lack of evidence. And I said, that's what Judge Hunter just told you, and this is the lack of evidence. If you can check off one of these boxes from Trooper what's-his-name's testimony, then fine, come back guilty. But if you can't, that's not guilty. And I'm so glad that we won that trial, because, God, I remember Thursday or Friday morning, whatever day the jury came back, I was really worried because they were taking so long.
Right.
And I thought, just the vibe I was getting
easier to return a quick verdict, I think, would weigh in your favor more likely.
With those facts. Yeah. Usually the longer they're out, the better. But I just remember I went for a run that morning in Gaylord, and I was just feeling, oh, man, they're going to come back guilty, and I'm going to just feel so horribly for Carolyn. She's such a nice person, and she's been through so much, and we put so much into this case, and Rob's going to feel let down. And
before you get the call, right?
Which call?
The verdict. We have a verdict.
I would not leave the courtroom.
Yeah, at some point they tell you we have a verdict.
Yeah.
Tell me what your heart rate does.
It was probably from 84 to at least twice that. And, you get this feeling in your stomach.
Does that ever change?
No, it never has. I mean, your stomach, you get this knot, and, you're trying to just control your emotions because you want the client to not worry.
Right.
She had a lot of supporters in the courtroom, and you got to go up to all those folks and say, okay,
we have a verdict.
We're going to do this.
Mr. Nichols, we have a verdict.
We're going to do this with class, right, folks? We've been classy all week. Right. We're going to continue to be classy, no outbursts, regardless of what it is. And, that's the sweetest moment, man. Oh God!
Yeah.
I'm emotional thinking about it. It's just so. I mean, you can see my eyes are welling up with tears
every time.
Oh my God! You're just sitting there, and when they say not guilty, you just go, oh, thank you.
Yeah.
Yeah.
It's the seven wonders of a world. There's the Catholic Church has all those things, but to sit there in that moment, and it's the same when it's guilty. You're just devastated,
right?
And when you win, it's thank God. It just is a miracle that you can convince 6 or 12 people,
right?
I want to talk about another case that we did, not necessarily we did it together, but
there is more.
There was another case up north that we did. This was a civil case up in your sort of hometown.
Oh yeah, okay.
Higgins Lake area, right?
Okay, I thought you were going to go with the "Don't drink the Kool-Aid."
Yeah, no, that was local. And we've done,
that was a great closing
even the
argument.
cases where you haven't appeared on or I haven't appeared on. And this is what I think is important. Is that it's important to have.
I gotta wipe my eyes.
Yeah. It's important to have a village of people, professionals that you can call on to consult on cases. And you call me all the time, what do you think of this or what do you think of that? But the case we did up in, I think it was Roscommon,
yeah.
right? And that's where you grew up, right?
Yeah. And where they went scrambling in that ORV is right across County Road 100 from the trailer park.
So
I lived in.
We talked about homicide cases that you've done. We talked about drunk driving. This is a little bit different because it's a civil case.
Yeah,
and,
a lot different.
Yeah, well, I mean, the fundamentals are the same, right?
The evidence, the law.
You want to study the facts, right?
Yep.
It's important that and how you learn the facts, right? You talk to the clients, you talk to everybody, you read the police report, you talk to the police officers, right? And you go to the scene, right?
Go to the scene 100%.
Yeah. And we did that, right?
We did that, I think, more than once. And we found things that, had not been discovered yet, I think. And one of my favorite things that I did was, so the young man who was operating the ORV.
Let's give a little bit of backdrop.
Okay.
A couple of, several, maybe 5 kids under 21.
Yep, 5.
Are up north on Higgins Lake, and
it's COVID. We've just had the shutdown,
and they decide they're gonna. The homeowner son decides he wants everybody to go to ride in the ORV,
and they'd been drinking all afternoon and evening.
They get in the ORV, and he originally says he's going to keep them on property, but takes off and goes like a bat out of hell all over Roscommon. And in that particular area,
Higgins Lake, actually.
Higgins Lake, in that particular area, the roads sort of all looked the same. And it was after dark, and he had thought he turned down his road, and he turned down a road short, which
dead ends.
It dead ends into trees, and he went flying off the road and hit a tree.
He kept flicking the lights on the. It was like a Polaris Ranger, right?
Right.
He kept flicking the lights off.
Yeah. So on those types of vehicles, there is no black box, right?
No black box.
So you don't know the speed of the vehicle by a black box. You got to determine it from physics.
Right. You got to do good old-fashioned accident reconstruction.
So tell me what you were going to tell me, if you can remember, about what you did in that case that was maybe special or something that you took with you.
Well, we just worked our butts off, and that's for starters. But I remember going, because the kid was charged, the driver was charged with, and he could not, they didn't charge him with operating while intoxicated. So Judge Beebe, the district court judge,
left the scene.
She was the prosecutor then, and she said, I don't think I can prove that, so I'm not going to charge that.
Right.
She charged him with reckless driving, causing serious injury for your client and my client. And
that's a 5-year, right?
Yeah. And one other charge, because he literally got up in this, it was horrible scene. It was like a war zone with my client and your client. They were screaming in pain and first responders were there trying to save him. They were so blessed that a nurse lived right there, and she, went to render aid and calm everybody down. They literally snuck their kid away.
Yeah.
They snuck their kid away so that he wouldn't be detected,
Right.
and they wouldn't be able to do a blood draw. So they took him to Old Grayling Mercy Hospital. Now it's Munson, I think. I've been there many times. And as soon as they told him they were going to put a needle in him, he left.
Right.
And it wasn't until like 4 o'clock in the morning, 4 hours at least after this thing happened, the cops finally got him to come out of the house. And by then it was too late to be able to get a blood draw and try to prosecute him for drunk driving. But they still charged him with felony. So I went to the preliminary exam because my client was going to testify. And I think you had somebody there too because you were doing something else. And I could just tell my client was so emotional about it because they were best friends, man.
Right.
They were so tight, thick as thieves. And he had to testify. So I, used my phone and took video of him walking down the hall. And I literally interviewed my client like, good old Cub reporter Mike Nichols would do. And I just said, what was that like testifying against your friend? And he got really emotional. And we put all that together in a video.
Yeah, that was great.
And for purposes of trying to resolve the case, I thought it was helpful. So that was one fun thing that we did.
Did you also interview the nurse?
I did.
Yeah.
I did.
We had a recorded interview with her.
Yeah, she was awesome.
And we deposed, obviously, the at-fault driver.
And his parents.
Because
part of the theory was they allowed that. Right. It's called negligent entrustment. And, I have...
And that was a case we settled.
We settled. And it was, I thought, a good settlement. It's weird how you get disappointed by the conduct of people. And I was just really disappointed in a lot of people on that. I mean, the way they just refuse to acknowledge, okay, we feel really badly, we should have done some things differently. They doubled down. It's almost like I would see them sneaking their kid away from the scene time and time again during the deposition.
Yeah, and
that's where you want to say, how can you sleep at night?
My client had agonal breathing. I mean, he
almost died.
Yeah,
went through the windshield, right?
Yeah, lucky to be alive, but he's bounced back and he's doing well now.
Okay, awesome.
So you sort of now delved into the civil side. What do you think of that?
The civil side is fascinating because there the expertise you got to really try to master on some level is the medical issues. Because when you sue somebody, it's over the injury. That's where you start, at least. Pain and suffering is you can recover money for the pain and suffering that somebody went through, but you don't get through the door without a sufficient injury. And so it's been enjoyable to learn that. I mean, Wendy has always been enthralled by the medical stuff.
Wendy, your wife.
Yes, and partner. Who we talked about the last time.
What do you think is harder, getting a not guilty or getting a jury verdict where they return money?
Ooh, great question. Well, I haven't tried one of those personal injury cases yet. I really want to do one.
You've settled some big ones.
Yeah, I'd like to second chair one with you next time you try one, and I can sort of learn because it's the opposite, right? You got to the jury has to push a different button.
You have to meet the burden of proof.
You have to meet the burden of proof, 50% plus a feather. But then when it comes to getting that burden of proof button pushed, you then got to get the number that you think your client deserves pushed.
Right.
And, I've listened to people talk about it and, read and listened to podcasts and gone to some conferences with Wendy. The art of persuasion from that side of it. There's a lot that's the same because it's the three... That's Aristotle's triangle of persuasion, but there are a lot of differences too. Because you're telling maybe a jury in Roscommon
how to ask for money is different than
Right.
getting a not guilty.
I think this case is worth $6 million, and here's why. And they all of a sudden are like, whoa, 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 whoa!
Right.
You're just trying to hit the lottery with this, Mr. Nichols. This is not your lottery ticket.
Right. Well, that's another hour on the A list for you.
Are you kidding me? It's been an hour?
Yep.
Wow.
Great job.
Well, we're recording this on President's Day, so I'll hopefully have time after we're done to keep organizing, and I'll still be reflecting on Iz winning that big one Saturday night,
Man,
354.
We've been at a great season. A lot of big wins.
People take for granted the blessing that we've had 30 years of that guy.
Yeah, I wouldn't say we take for granted, but we're gonna miss. He gets a lot of credit. He also gets a lot of criticism. There's
Takes
a
a lot-
lot
it
of
takes a lot of-
people
yeah.
that thought he couldn't work the portal, and it was like, he gets paid a lot of money to make decisions, and I'm good with him making those decisions. There's not too many people that could do what he does.
Right. With that consistency, that level of excellence year in and year out, that's really, really impressive.
Yeah. Anyway, all right. Great job.
Thank you.